Just received that motion in the second. So we're asking the court to adjourn this matter.
Okay, is Mr. Grissinger here today?
Yes, he is.
Yes, okay. All right. And Mr. Rowland?
I don't know why they would say they just received. I'm looking at the date it went out now. Give me a moment, I'll get back to that information.
Oh, I've got it filed on April 1st.
Okay, well, again, I know I had it done before the Easter weekend. I don't know exactly when it hit the court, so that may very well be the case with the holiday since courts were closed for Friday.
All right, so Mr. Gila, if we reset this for next month, would that be enough time?
That'll be enough time, Judge.
We have no objection to that, Judge, for the record.
Okay, all right, given that the motion was just filed, the court will grant the request for adjournment. We'll set it for a hearing along with the status conference for 30 days. So Mr. Grissinger, just make sure that you continue to stay in touch with Mr. Gila, okay?
Yeah.
Thank you.
Thank you, John.
This is Ann Slazinski, case number 246694.
Your Honor, I call that people.
Jerry, you on.
Ms. Slazinski, you can just sit right there at council table. Injury to your leg there. And how did we want to proceed in this file today, Mr. Kilo?
Judge, this morning my client's going to enter a guilty plea as charged with the complaint.
Ms. Slazinski, have you had a chance to speak with Mr. Gill about entering this plea today?
Yes, sir.
And is that how you want to proceed?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Slazinski, are you currently on any kind of probation or parole?
Probation
You're on probation. Where is that out of?
here.
And is that felony probation or through the district court?
Both.
You're both. You're on. Are you on two different kinds of probation?
I'm confused about that.
Okay. Who do you report to for your probation? Who's your agent?
Natasha and then Jessica.
Okay. Do you know Mr. Gilar, these district court probation?
Your Honor, it's district court and community corrections.
Okay. So one is for bond and the other is criminal. Okay. All right. So Ms. Lazinski, do you understand that by pleading guilty today that could result in a violation of your probation?
Yes.
And that by pleading guilty, the maximum possible penalty that you could face for this charge would be up to 5 years and or $5,000 fine?
Yes.
With all of those things in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes,
This happened on November 28th of 2023. Is that the correct date?
yes,
On that date, had you been consuming alcohol?
yes,
And after you consumed alcohol, did you operate a vehicle on Court Street here in Gaylord?
yes.
And at the time that you were operating that vehicle, how much did you have to drink prior to operating that vehicle?
I'm not sure.
Okay, can you guess?
For the record, Your Honor, we stipulate the toxilizer, which is that machine in the jail, was a .095.
That's correct, Judge.
All right, so if a test showed that your blood alcohol content was 0.09, do you have any reason to doubt the accuracy of that test?
No,
Had you previously been convicted of operating while intoxicated on November 3rd, 2023 in district court here in Gaylord?
yes,
Had you previously been convicted of operating while intoxicated back in May of 2017 in St. Ignace District Court?
yes,
Mr. Rollard, are people satisfied with the factual basis?
We are, Judge, and I would also indicate for the record, people did agree, even though the defendant has multiple driving license suspended priors and was revoked, we were not going to issue additional driving license suspended charges. And I would indicate that there is $100 reimbursement for the intoxicator breath test. Thank you, Judge.
Mr. Keel, as to the factual basis.
I'm satisfied you have a factual basis.
Other than what you've just stated, Mr. Rollard, are the people aware of any threats, promises, or inducements?
No, Your Honor, thank you.
Mr. Keel?
No, Your Honor.
Mr. Rollard, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Keel?
Yes, Your Honor.
Thank you. Ms. Lizinski, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Gilo so that you're prepared to go forward on that day. Before you leave court today, you're going to meet with Ms. Davis. She's going to set up a time with you for a pre-sentence interview. And that's all for today. Thank you.
Thank you, Your Honor.
And
Purple orders.
Travis Brandow.
Yes, Your Honor.
Okay, we're on the record now in Lundell versus Brandow. This is case number 11-13907. The record should reflect that Mr. Brandow is appearing today by video from Otsego County Jail. We have Ms. Kraus connected by Zoom on behalf of a friend of the court. Mr. Brandow, you're before the court today for arraignment on a bench warrant regarding your failure to appear for a child support hearing. Do you understand why you're before the court today?
Yes, Your Honor.
Okay. And Ms. Kraus, have you had a chance to speak with Mr. Brandow, or how does the friend of the court want to proceed today?
Well, the defendant has a support obligation of $371 and a balance of $21,797.24. The last payment of $198.55 was received in January of this year from a prior income withholding order. A bench warrant was issued on February 6th of 2023 in the amount of $5,400 for his failure to appear for a show cause hearing. While the defendant was pulled over on April 1st at approximately 4 p.m., he contacted the office to resolve the bench warrant. I was out of the office and he spoke with a staff member. He indicated that he has a new employer. Friend of the court would first like to confirm how the defendant is paid and how long he has been employed, as the paperwork he completed at the jail indicates he's recently obtained employment.
Okay, Mr. Brandow, can you speak to that?
Yes, ma'am. I was recently laid off from the oil rigs. on December 29th. I'm waiting to go back there because of frost laws, and I was making my obligations, but I couldn't get that warrant dropped. It stayed on there. I recently, literally, my father-in-law passed away 2 weeks ago. I took some time off to help him get through his cancer, and he just passed away. His funeral was this Friday. It's at Nelson's. I just started working for Joe Scott on Main Street. My wife has his phone number. It's for construction, and I get paid every week. And I could do $100 a week. My family, we don't have the $5,000 right now. I do have like $1,000, $1,500 I could give you to get out of here. A lot of those, when I fell behind on my child support, I used to get high. I used to be a piece of crap. I'm not anymore. Like, I've actually been doing really good. I got married. I'm off drugs. Judge Mertz actually is the one that sent me to prison. And I've been doing good. It's just my rearages I know they're bad, and I know I need to get them taken care of.
Is the employment based on like 1099, or would taxes be taken out of that employer?
It's 1099, but you can call Joe and I get $20 an hour. And I could even make a promise to you that I can be up at the front of the court every Friday as soon as I get paid, and I can drop money off. And I can show you my paycheck if you want me to.
Your Honor, friend of the court would be open to bond being reduced, but would indicate the defendant has a history of failure to appear and a lack of consistent payments.
All right, so Mr. Brando, here's what I think is a reasonable way to go forward. Can you make a $500 payment as part of the bond to be released? Okay, so I'm gonna lower your bond to $500. So once you make that $500 payment, you'll be released. Then not the day after tomorrow, not this Friday, but the following Friday, I'm gonna order that you make a $100 payment that Friday.
The 12th.
Yes, sure.
Which would be.
Yes, Your Honor.
Which would be April 12th. And then.
I can do that.
Okay, and then what's the last Friday?
Last Friday is the 26th.
And then another $100 payment on April 26th.
Yes, Your Honor.
And then we'll set this for a hearing in May. If you've made those two payments, then Ms. Kraus, then let's continue to monitor payments, and then we'll take that hearing down in May. So you won't have to appear if you make those payments, okay, Mr. Brando?
Okay. Yes,
But
Your Honor.
then you'll need to continue making payments, but we also need you to get with the friend of the court and make sure that they have your current employer information once you're released from jail.
I will.
Okay, Ms. Kraus, anything further that we need to address today?
No, outside of the employer, if he can actually, if it's possible, stop by, because he did attempt to update his address, but the quality of the facts, I was not able to decipher what that address is.
As soon as my wife drops off the $500, I'll come up there afterwards.
Okay, sounds good.
All right, thank you.
All right, very good. Thank you. That's all for this hearing today. Okay, we're calling for Mr. Evans.
Can you hear us?
I can. Can you hear me?
Yes, I can.
Okay. All right, Mr. Evans, are you able to hear me okay?
Yes, I can, Your Honor.
Okay, we're on the record now in People versus Jason Evans. This is case number 236554. The record should reflect Mr. Evans is present by Zoom video from Alpena County Jail. If I could have all council put your appearances on.
Morning, Your Honor. For the record, Michael, on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Evans.
All right, Mr. Trush, this is set for a status conference in this case today. Can you tell me how we're gonna proceed?
Yes, Your Honor. So to give the court an update, when we were last here, we were still compiling information. I'd taken over from Mr. Pfeiffer. There's a lot of information outstanding, missing, that had to be tracked down in order to discover if it actually existed. I'm happy to report, I think we've almost got everything compiled. There is a transcript that I don't think was ever ordered that we need to get done. That generally takes about 60 days or so to get completed. So in terms of being ready for a trial, I think we're still a little ways out from that, but I think that's the only thing really still outstanding that has to be provided or compiled.
All right, I mean, do you anticipate proceeding to trial in this case?
Well, Your Honor, that brings me to my next point. So what I'm ultimately going to ask the court to do, I think, is set this for the mid-month day in May for a status conference. And I'm doing that in anticipation that we're going to ask to move his scheduled sentencing date to that date. He's scheduled for sentencing at the beginning of May. His trial in Alpena is the day after his scheduled sentencing here. I have I think, well-founded concern that MDOC would be uncharacteristically efficient and it would interfere with his trial there. I've talked to the prosecutor about this. I don't think he has an objection. I don't think it prejudices anyone to do it that way. So that's the anticipation. Our hope is, I've been in discussions with the prosecutor about some potential resolutions, but we are, I think both sides are concerned about sort of the far end of either spectrum. So this case presents some unique sentencing characteristics in terms of potential dead time, potential consecutive sentencing. I think the prosecutor has concerns of the far end being low end of guidelines, no consecutive sentencing. Obviously, my client has concerns about the other far extreme being the high end of the guidelines and potential consecutive sentencing. Given the unique circumstances here, and I know the court disfavors this, but we're hoping that the court may be willing to engage in like a Cobb's style discussion.
Okay. In terms of moving this to the mid-May date, Mr. Rohr, do the people have any position on it?
Thank you, Judge. Mr. Trish and I met yesterday for well over an hour on this and other cases. We discussed that scenario. I think with the issues the defendant has in Alpena and as they might impact his availability for hearings here, the people have no objection to the court moving both Mr. Evans's current sentencing date for the early of May on his other file to be on the same date and time as a next status conference, in this case, somewhere in the middle of May.
Okay, so you don't have any
No
problem
objection,
with
no
that.
judge.
All right, so we'll move the next status conference in this case to the mid-May date. I guess I'm confused at what the concern is regarding the sentencing at the beginning of May in relation to his trial date in Alpena.
So
I mean, I'm assuming are you worried that they're going to take him to intake somewhere?
yes, my concern, and again, I would say that it would be uncommon for MDOC to act so quickly, but it also seems to me that it would be the exact scenario where it would happen, right? When he has a trial set the very next day. And then, I mean, that obviously creates substantial issues because you can't do a writ before, but before he's in MDOC, they can't writ him for his trial that date. So that's where my concern comes. In the event that he's sentenced, I think a probable sentence is likely to be an MDOC sentence. So my worry is, does he wind up getting whisked away from Alpena to MDOC on the eve of his trial, essentially?
And Judge, in that regard, since his sentencing on the other file is currently set for the beginning of May, the scenario Mr. Trish just described is not unrealistic.
Ms. Davis?
Your Honor, they're gonna bring him over to our jail for sentencing. Then our sheriff's department are the ones who transport him to prison. So MDOC does not pick him up, our sheriff's department transports, so if that trial is that week, you can coordinate with the sheriff's department on not taking him to prison until the trial is
Yeah.
completed.
All right. I mean, I get what your concern is, I just don't see realistically that somehow somebody's gonna come and take Mr. Evans away and he won't be able to have his trial in Alpena. I mean, we're all kind of in control of that. So,
I guess I'll say I tend to assume the worst of MDOC, because that seems to be always what happens.
all right, well, I mean, I tend to agree with Ms. Davis, it's our county that would have to do the transporting. I order Mr. Evans to be taken from here to Alpena for his trial the next day. I just don't see that as a problem, so I'm not gonna reschedule the sentencing. I think that hearing needs to take place, and frankly, I'm concerned about just, and I'm not putting this on you, Mr. Truish, or trying to imply that you're doing this in some way, but I have concerns about Mr. Evans' attempts to delay the consequences of that conviction. And my concern is we're gonna get to mid-May motion day for a status conference in this case, and there's gonna be another reason why sentencing needs to be delayed. So we're gonna have sentencing as it's currently scheduled. I will move the status conference in this case to mid-May. If Mr. Evans is no longer in custody of one of the counties, then Mr. Roloff is asked to do a writ from MDOC for Mr. Evans for that mid-May motion day. And then we'll see where we're at in terms of any type of agreement. I will also say that the court is not going to engage in any kind of sentence bargaining for Mr. Evans. So I'm not going to sanction any of plea agreements that contain any kind of sentencing agreements, and the court isn't going to participate in any type of COPS sentencing agreements. So the plea agreements will be what it'll be, the guidelines will be what it'll be, whatever the other sanctions will be what they'll be, that'll be all put into a report, and the court will impose a sentence that it finds reasonable and applies with the statutes. So just want to put everybody on notice. I don't know if that'll help your negotiation or not. So anything further that we need to address today, Mr. Trish?
No, not from my perspective.
Mr. Rowland?
No, Your Honor, thank you.
Okay, Mr. Evans, did you have any questions at all?
No, but if Mr. Truce has time, could I have a breakout room with him?
Mr. Trush may be able to get in touch with you separately, but I don't. Actually, that's up to you. We have a few minutes, Mr. Trush, if you want to sign in on a different device.
Your Honor, I would prefer to just schedule a call with him for a different day.
Okay.
Jason, I think likely I may be able to get a call scheduled with you Friday, but I'll call Alpena's jail and figure it out, okay?
Okay, thank you.
Yep.
Okay, thank you. We're going to disconnect at this time. Do you have any of your other clients ready, Mr. Trush?
So on the 9:30 docket, Mr. Susslick is not here yet. Mr. Barnett is lodged in MDOC.
Okay, and I believe Mr. Ball, is he lodged downstairs?
Nope.
Had him on the jail list. But-
He's not any longer, he should be here in person.
Okay, all right, let's take a short recess and we'll come back on the record in about 5 minutes. All right, sir, can you tell me what your name is there at Department of Corrections?
That is Mr. Barnett.
Oh, it is.
I-
Mr. Barnett, are you able to hear me?
I mean, I think he can hear us. I think it sounds like the audio is just extremely faint.
No, I got it turned on. They had it muted.
All right, thank you. We're on the record now in People versus Zachary Barnett. This is case number 236659. Mr. Barnett is present today by video from Department of Corrections. If I could have counsel put your appearances in.
For the record, John, Mike, on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Barnett.
How did we want to proceed today, Mr. Trush?
So, Your Honor, so Mr. Barnett has this matter here. He also has a matter over at Presque Isle County. We have an offer in this case that we are inclined to take, but we've been waiting on the other matter to potentially resolve or not. Depending on what happens there is kind of controlling what we're doing here. I believe he had a hearing on Monday over in the other county. I've been playing phone tag with Mr. Gilbert, his attorney over there, but I don't know what happened in that hearing.
They pushed it off until the 22nd.
So, Your Honor, I guess I would ask the court if the court would give us another adjournment. Again, we intend to take the offer here, but the problem is, again, the other county. And my understanding is what Mr. Gilbert is trying to do there is have the offer essentially match the offer here. And the charges are substantially similar in both counties. So that's where we're at. And I mean, I wish I had a better answer for the court than that, but that's where it is. And I mean, his concern obviously is if he can't resolve both of these, again, he's looking at potentially the 25-year mandatory minimum in the other county. So.
All right, Mr. Barnett, can you tell me why that hearing was moved to later this month?
Yes, the prosecutor is supposed to talk with the victim and her mother and to figure out if they can accept the plea deal that I offered. That's the only reason he really said is that he wasn't sure they wanted to accept it yet. And that they wanted to talk.
Mr. Roloff?
Judge, I can confirm for the record, there is a plea offer that's been made to the defense. I cannot, however, comment on the other county. In fact, our record doesn't even indicate what county that is. So I'd appreciate knowing that information.
Sounds like Presque Isle.
Yes.
Okay, very good. Thank you.
All right, so this is already been adjourned a number of times, so, but these are serious charges, so I'm willing to grant a little more leeway given the potential sanctions that Mr. Barnett's facing here. So, but with that in mind, at some point, I don't want to engage in a back and forth adjournment process with Presque Isle where both sides are playing against each other, waiting for one to make the first move. So I'll grant one more adjournment, but otherwise, at that point, the court, I'm gonna make that a plea cutoff. And if there's no, we don't have a plea entered at the next date, the court's gonna set it for trial and there won't be any further pleas to any lesser charges, so.
And Mr. Barnett, just to confirm, you said they moved it to the end of this month?
Yeah, the second.
Okay. Mr. Rolla, anything further on this case?
What date did he indicate is?
April 22nd.
22nd.
22nd, okay, because for a second I thought he said the second. I'm going, does he mean May? No, Judge, I would ask, if you don't have an objection, one more adjournment, but we would ask that it be a final cutoff then for whatever the next hearing date the court sets. Thank you, Judge.
Okay. All right, so I guess Mr. Truce, just make sure that you have those discussions with Mr. Barnett and make sure that Mr. Gilbert is aware that the court isn't gonna adjourn this matter any further in this county.
Understood. I appreciate the consideration.
Mr. Barnett, do you have any questions at all?
No, sir, and thank you for the extra adjournment.
Okay, thank you. That's all for today, and the court's gonna disconnect at this time. Okay, People versus Cecil, case number 236612.
Director General, my program, people.
Thank you, Your Honor. Richard Church on behalf of Mr. Seslick.
Okay, this hearing was set for 9:30. It's now 9:45. Mr. Seslick does not appear to be present here in the courtroom. The court also notes that he failed to appear back in March. Have you had any contacts with him?
I have, Your Honor. So I had contact with him last week leading up to today's hearing. We were intending to ask the court to set a trial. I messaged him this morning, just short of 9:30, asking where he was at. He told me he doesn't have a ride and can't make it. Frankly, I explained to him, the hearings aren't optional. He can't tell me, minutes before his hearing that he can't make it here. That's really all I've got, Your Honor.
Okay, Mr. Rolla, do people have any objection to issuing a bench warrant, given that this is Mr. Seslick's second failure to appear?
Actually, Judge, we're gonna request that the court do so in light of his failure to appear back on March 6th earlier this year.
Okay, so based on his failure to appear in March and today, notwithstanding his call to Mr. Truce, the court will order that his bond be revoked, that a bench warrant be issued, and will proceed further once Mr. Seslick's arrested and brought before the court. And People versus Ball, Derek Ball, case number 236597.
Your Honor, Mr. Ball is present in the courtroom. I would ask if I could have a minute to speak with him. We had some corrections to the report. Just want to make sure I didn't miss any.
Okay. Miss, is it Bose? Is that how you pronounce your last name, Counselor?
Boss, Your Honor.
Boss, okay. Ms. Boss, Mr. Ball and his attorney, Mr. Truce, are present in the courtroom. They're just having a short discussion here, and then we'll start the hearing, okay?
Sounds good. Thank you.
Thank you.
Yeah. Thank you.
Sure. Thank you. Okay, Mr. Truesdale, are you ready to go?
I am, Your Honor.
All right, we're on the record now in People versus Eric Ball, case number 236597. The record should reflect that Mr. Ball is present here in the courtroom today along with his counsel. We have Ms. Voss on behalf of the state appearing by Zoom today. This is the date and time set for sentencing. Mr. Ball, have you had an adequate opportunity to go through the report and speak to Mr. Trush about that?
Yes, Your Honor.
Okay. Mr. Trush, are there any additions, deletions, or corrections?
Yes, Your Honor, we do have a couple corrections that we would make. On CFJ 284, page 2, defendant's description of the offense. The report says that he's declined to provide a statement, and we did want to provide a brief statement today.
Okay, defendant declined to provide a statement, but will address the court at sentencing.
Well, Your Honor, I had two sentences that I wanted to put in there.
Okay.
And that's while the defendant maintains the order from front of the court is not correct, as his children lived with him for periods of time during that order, he does acknowledge that he did not follow that order.
Okay, Mr. Roll, any objection to including that? Or I'm sorry, Ms. Voss.
No, Your Honor.
Okay, we'll have that added to the defendant's description of offense.
And then the second area is on CFJ 284, page 16. And the first correction is going to be in marriage narrative, right up there at the top.
Okay.
The last sentence there in that marriage narrative says the defendant has been in a dating relationship with Tabitha Turner for the past 6 months. It's actually 6 years. I think it's just a typo.
Ms. Voss, any objection to that change?
No, Your Honor.
Okay.
And then our last correction is on the same page in the education section. It indicates that he has a GED from Gaylord Community Schools. In addition to that, he has a Bachelor's of Applied Science from Ferris State University.
All right, Ms. Voss, any objection to adding that?
No, Your Honor.
Okay. Any other corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Voss, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
None.
And did you have any victims that wish to address the court on this case today?
None that I'm aware of, Your Honor.
Okay, anything on behalf of the people for allocution then?
Mr. Ball is still owing $46,013.72 in arrearages. We would defer to the court as to his sentencing today, although we have agreed to an 11-month delay of sentence, it appears.
Great, thank you, Mr. Truce.
Thank you, Your Honor. This case is unique in the sense of, I think what we truly have here is a situation where someone has been kind of pushed out of the process. And what I mean by that is Mr. Ball accepts that he did not follow the order, although he's maintained to me, and from speaking to his children, I think there's factual support of this, that they lived with him for periods of time, substantial periods of time during this, where these arrearages were accruing. The failure here on Mr. Ball's part is, he's got to go through the process and get that corrected. He has to go to the court and have it changed. And I understand how some people kind of get sidelined from the system and feel like they can't go in there or don't want to go in there or don't trust the system. But that's the remedy that he has to correct that issue. If he thinks it's wrong, and again, from the information that I have, I think it is wrong, he's got to go in and get it corrected. Otherwise, it just keeps accruing and he gets himself into a hole like what he has here. The benefit here, and I appreciate the Attorney General for extending a delay of sentence offer here, is it gives him some time to go to the court and get that corrected. And I've talked to him about that. He started the process in the past, but hasn't followed through and finished it for a variety of reasons that I've discussed with him. But at the end of the day, he really has two choices. Choice one is he's got to pay the arrearage, and he either accepts what it is and pays it, or choice two, he's got to go to the court and get it corrected, and then he's got to follow the court's order after that correction. And that's really what it comes down to. I am optimistic, and I think from the report, Mr. Ball is as well, that he's going to be able to go there and get that corrected. And once the numbers are accurate, I think we're going to see a substantial portion fall off, and I think we're going to see him be able to make the progress he needs to do it. There's a substantial bond in this case that I think either has been or will be applied to the arrearage. I think $15,000. So I think once those things are done, it's going to be a very manageable number for him. We're going to see some real progress that takes place here. So I would leave the court with those ideas in mind in terms of the sentencing here today. I think when we're back here at the end of the delay, that we're going to see someone in a substantially different position.
Great, thank you, Mr. Ball. Anything that you wanted to say?
I realize what I've done wrong here with not following. I tried to address the court. The referee ordered that it be corrected twice. Judge Cooper ordered it once. The children lived with me from 2017 to 2021. Graduated high school, moved on, so on and so forth. I think, as Mr. Truce said, that with the corrections, it's almost $30,000 that can be corrected, and then I can pay the rest.
Okay. All right, well, now is the time to get this hammered out. You've got 11 months through this delay, and I think given the circumstances here, it's appropriate to follow the agreement of parties for the delay. It sounds like you're in a position where if what you're saying bears out, that you could get a substantial portion of this arrearages adjusted in your favor. But again, I think your time to do that is now. If you wait, you're just going to rack up more penalties for yourself. So the court, I think it's appropriate to give you an opportunity to do that. Parties have agreed to it. I don't see any reason for the court to get in the way of that. So the court is going to sentence you to a delay of sentence probation. It is going to be a term of 11 months. The court is going to adopt as the conditions of that delay all the conditions that are listed in the report. And that includes payment of $130 crime victims assessment, $30 monthly supervision fee, court costs of $325, and attorney fees of $350, estate costs of $68, along with the other terms of the delay, which are to address your arrearages and current monthly payments. because this is a delay of sentence, there are no appellate rights at this time. However, Ms. Davis, are you gonna be the supervising agent?
I am not.
Okay, so we just need you to meet with Ms. Davis here after court to make sure that you go through all your conditions and that you fully understand what you need to do over the next 11 months. Mr. Trush, anything further that we need to address today?
No, Your Honor.
Mr. Rolla? Or I'm sorry, Ms. Boss.
No, nothing further, Your Honor.
Keep leaving you out. You're on the screen to the left of me. So I apologize for that.
That's all.
Did you say nothing further on your part?
Yes, Your Honor, nothing further.
Okay, thank you. And you're free to disconnect at this time.
Thank you, Your Honor.
Like me going forward, Mr. Paul. Need a chance to talk to Ms. Curtis, Mr. Chairman.
I do not.
Court will call People versus Rebecca Cruz, number 236663.
Thank you. For the record, my call behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Ms. Cruz. I did want to confirm one thing with the court.
Sure.
I received a letter from Ms. Cruz on the 1st. We sent that to the court yesterday, but I just wanted to confirm it.
And I did have a chance, I did receive that and I did have a chance to review that prior to today.
And Mr. Rolla, did you get the same?
Which, hang on, I'll find the phone. No, it's not. No, Judge.
Okay. Ms. Cruz, have you had an adequate opportunity to go through that report and talk to Mr. Trush about that?
About this letter that I just read on the 1st? Yes, sir. Yes, sir.
You did, okay. And Mr. Trush, I know we have 2 challenges to the scoring. Before we get to that, are there any additions, deletions, or corrections?
No, Your Honor.
Okay. And then I believe we have an agreement of the parties as to OB 18, that should be scored at 0. Is that correct, Mr. Rolla?
That's correct, Judge.
Okay, so the court will order that OB 18 be scored at 0. The other challenge is to OB 9. I did get the challenge, Mr. Trush's written brief on that, as well as Mr. Rolla's written response. Anything further that you wanted to add as to that?
The only thing that I would say, having reviewed Mr. Rolla's response, I think he reads the reports differently than I do. As I read the report, I think Trooper Zamaron is in the room with Ms. Cruz. It sounds to me like Trooper Carlson is outside the room and then comes back into the room at a later point. From reading the report, I would contend to the court that there is an officer placed in danger, Trooper Zamaron, when there's an attempted kick and an attempted bite. But it does not, from my reading of the report, I don't believe that Trooper Carlson is in the room when either of those things happen. And from the report, it sounds like once he returns to the room, Ms. Cruz has either calmed down or been subdued and has just returned to the chair. So I don't think it's appropriate to assert that more than one person has been placed in danger. And likewise, again, there's nothing in the report that reflects whether or not a phlebotomist was in fact in the room when that happened or not. Again, Mr. Rolla points to her tearing the cuff off, but again, I don't know that that puts anybody in direct danger. There's nothing in the report that would seem to me to reflect that. So again, while I understand the report can be read in 2 different ways, the court does have to find preponderance of the evidence to score it. I just don't think it's there.
Thank you, Mr. Rolla.
And again, with all due respect to defense counsel, a couple of things. First off, the report is very clear, as the police report, as the PSR, in addition to trying to both kick and bite Trooper Carlson, the defendant, Ms. Cruz, ripped off her blood pressure cuff in front of the phlebotomist while this is going on. That's at least 2 people, because that's her and Trooper Carlson. And I'd also indicate that defendant's reliance on People versus Phelps is inappropriate and it's distinguishable in Phelps, and that's at 288 Mishap 123 791 second 732, a 2010 case. It's completely distinguishable because Phelps is a CSC case where two of the victim's friends were present at the time of the sexual assault. However, as distinguishable from the first matter, in Phelps, they were witnesses only, and as specifically found by the appellate court, at no point in time were they threatened or in any way placed in danger at all by the defendant, and that's why the scoring originally as done by the trial court was inappropriate as ruled by the appellate court. In this particular case, as to Trooper Carlson and as to the phlebotomist, they weren't just witnesses. They were physical participants in the reactions as were done by Ms. Cruz, specifically in trying to resist the officers.
Thank you. Any response, Mr. Church?
Again, I would just to make it clear record, my reading of the report is that it's actually, and I said Trooper earlier, Sergeant Zamaron, who there was an attempted kick and attempted bite. I don't think Trooper Carlson was actually in the room when that happened.
All right, so the court does have to find when there's a challenge to a variable, particularly the offense variables, that there's factual support for the scoring. The court has to find that there is preponderance of the evidence to support the scoring. The court can go out of police reports, prior sworn testimony, information contained within the pre-sentence report, and so forth, making those findings. In this case, the challenge is to OB9 regarding the number of individuals placed in danger. And the court is referring to the police report that was attached by Mr. Rolla. I think it's clear based on what took place in the hospital room that Sergeant Zamaron was placed in danger by Ms. Cruz's actions in the hospital room. And then specifically, I'm referring to part of the narrative from Trooper Carlson, where he states that I left the room to go to apply for a search warrant for Ms. Cruz's blood. Once in the parking lot, I was recalled back into the emergency room by Sergeant Zamaron. I walked into the room. I observed Rebecca on the ground actively resisting Sergeant Zamaron and pulling away from him. I assisted Sergeant Zamaron picking up Rebecca to place her back on the hospital bed. So in my view, Trooper Carlson was actively involved in trying to restrain and get Ms. Cruz under control. And so as part of that process, I think it's clear he was much more than simply a witness or somebody who was present. He was actively involved in a resisting and obstructing situation. And certainly given Ms. Cruz's conduct at that time, both he and Sergeant Zamaron, I think by preponderance of the evidence, were placed in danger of being injured by her actions. So for those reasons, the court finds there is sufficient evidentiary support for scoring of OB9 at 10 points, and the court will deny that challenge. So that leaves us with an OB score of 30. And I don't believe that affects guideline range. Is that correct?
It wouldn't affect it either way, Judge, correct. It's still in the same scoring range.
That is correct. The maximum OB level on the G grade, I think, is 16 points.
So we're at, we remain at 0 to 11. Do you have any other challenges that we haven't addressed, Mr. Trush?
I don't, but I do apologize. I did have a correction that I forgot to bring to the court's attention.
Okay.
So on CFJ 101, page 2, on the section listed offense 2 of 2, I think the PAT code and the offense name are wrong. It should be 257 625 6B, and that's OWI second offense. I think it's readily apparent that Ms. Cruz is not a minor. I think that's a typo.
Any objections to that change?
If it's OUI second offense, it would be 257 625. Hey, that's correct, yeah, sorry. Thank you.
And in the same vein, likewise, on the next page, CFJ 145, page 1, the same issue exists on the current conviction section.
Okay. Thank you for that correction. Anything further, Mr. Church?
No, you're on.
Mr. Mr. Rolla, do the people have any additions, deletions, or corrections?
Other than what's already been indicated on the record,
Do the people have any challenges to the scoring?
no challenges to the scoring other than it's already been addressed on the record. Correct.
Anything on behalf of the people for allocution?
Just briefly, Judge, in light of the defendant's placing herself and others in danger and her blood alcohol was 0.200, the people believe that some jail time is in order. This is, I understand, and quite frankly, people appreciate now, although perhaps you should have had it a little earlier, the defendant's written statement, which now the court has to look at. And she is clearly, at least in that statement, taking accountability for actions and apologizing to the court. And that's a good thing. Perhaps maybe that message is finally been delivered, but to reinforce that message, in light of the circumstances in this case, people who drive the way she did, people who fight with officers the way she did, some jail time is appropriate. Thank you, Your Honor.
Thank you, Mr. Trush.
So, Your Honor, there's a couple things that I think are important to consider here. The first that I'm going to start with is Ms. Cruz has relatively minor prior criminal history. And that's in the sense that she has 3 prior misdemeanor offenses that the court can see, listed in the pre-sentence investigation. From 2010, she has an operating while intoxicated. In 2022, she has an open intox. I think both of those are in Florida. And then earlier in 2023, she has a second OWI and then the present offense. The thing that I think is remarkable and disheartening about this is, to this point, the court has taken no intervention at all. In her first OWI, the court can see she was issued a sentence of fines and costs. In her second alcohol-related offense, she was issued another sentence of fines and costs. In her third alcohol offense, she was issued a sentence of fines and costs. And this is incredible to me. How we get to someone who's all of their prior history is alcohol related, 2 prior OWIs. Everything screams there's a problem with alcohol. And no court has even placed her on probation yet. And this is stunning to me. And I say that in the sense of, I think it's stunning that she didn't get any intervention. I think, unfortunately, that reinforced the idea to Ms. Cruz that she didn't have as serious a problem as she did. Because again, the court system is essentially telling her she doesn't, by only imposing a fine to her. What I think is important here, she does recognize she has a problem. She recognizes that she has to address that problem. I think that bears out in the actions that she's taken, starting in October of 23, which is actually slightly before, I think, the offense date here. She had reached out and started the process of getting involved with Northern Lakes CMH and started the process of counseling. So I think that is relevant for the court to consider that, she did start without the court intervention here, recognizing she has a problem. She has been engaged in that since that time. I have a letter from them that basically, I don't even know that I need to provide it to the court to actually read the letter. It's from CMH and says that she began in October of 2023 and has been consistently utilizing their services for mental health and substance abuse since that time. So effectively since the offense. What I would suggest to the court, again, the recommendation for some upfront jail, given the circumstances, doesn't seem entirely inappropriate. I would ask the court to temper the amount of jail and maybe hold more in abeyance than imposing up front and have her continue the treatment. It appears to be working. And again, I guess what I would indicate is it's unfortunate we get to this point before any intervention happens. But I think we also know that our outcomes from intervention and treatment related activities are generally better than our outcomes from incarceration related activities. Which is to say, I mean, if we put her in jail for 30 days, when she's released in 30 days, we know that she hasn't changed any behavior because she hasn't got any counseling or anything in the jail. Treatment-based outcomes tend to result in better outcomes.
Thank you. Ms. Cruz, anything you want to say today?
I apologize, Your Honor.
All right, I did read through the report, I'm familiar with what happened in this case. I obviously had access to the police report, which I don't always do because of the challenge to the scoring guide. Reviewed that. I reviewed your letter as well that you submitted. And taking all things into consideration, I guess there's a couple things I would say. Number one, your behavior during this incident from start to finish is completely unacceptable for an adult to behave this way. Not only towards law enforcement, but your actions in getting in that vehicle and in a condition where you clearly should not have been operating a vehicle and could easily have injured or killed somebody else, even though your drag was short, it was in a way that had anybody else been crossing that road at that time, that's a completely different outcome. And that's concerning to me from a standpoint of community safety. I understand Mr. Trush's point. I take issue with that a little bit because number one, I think the court system is here to force you to do things like treatment and so forth if you're not going to do it on your own. But I think, as mature adults, when you see that things aren't going right, we have a responsibility to take care of those things on our own and just to say, well, the court's not making me do it, so I guess I don't have to do it, and it's not a problem. That's not the right way to look at things. Court is here to make you do it as kind of a last resort, but to expect that the court's going to make you do something, and unless the court makes you do it, you don't have to do it or you don't need it. I think it's just not the right way to look at things. And the court's now operating under mandates from our legislature that first, second offenses, non-violent offenses aren't supposed to get jail time. So the legislature's telling courts not to impose jail time. So I don't know whether Judge Cooper or anybody else thought that you should have gotten jail time as opposed to fines and costs for some of those first offenses, but didn't impose it because of the new mandates from the legislature. I don't know. So again, the fact that you weren't placed on probation, that you weren't forced into treatment by a court prior to this, or that you weren't put in jail, I don't think any of that gives you a reason to continue to offend. And I don't think any of that provides an excuse for you or places the burden on the court for your behavior in this case. And I do think that some jail time is appropriate here based on your actions, based on the danger that you put others in when you operated the vehicle, based on the danger that you presented to the police officers who were simply trying to do their job and protect people from people like you in the condition that you were in. And your behavior towards them and towards the hospital staff is completely unacceptable, and putting you in jail isn't going to help you deal with that problem, but it is going to provide some consequence and some punishment for you, so you understand that you can't just behave that way and expect that there isn't going to be a consequence, and so that other people see that there's a consequence towards behaving that way. I do think that some probation is appropriate here to monitor what you're doing over the next 2 years to make sure that you get on the right path and that you stay on that path. The court is going to follow the recommendation and place you on probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to impose 90 days in the Otsego County Jail. You do have credit for 2 days served. The court's going to order that you serve the first 30 days of that up front. The court will allow you to be released to the work camp program for the remainder of that sentence. The court is going to order restitution in the amount of $625 that's payable to the Otsego County Clerk to be dispersed to Michigan State Police for damages. $130 in crime victims assessment, a supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, and $118 state costs, and that's combined for both charges in this case. You do have the ability to seek an appeal of this sentence, and Mr. Trush can provide those appeal rights.
Judge, is that a combined sentence for both counts 2 and 5?
Correct. Sentences around concurrent.
Thank you.
And 2 days credit if I didn't say that. And then we'll need to go to the office.
Returning to the court, the executed advice.
Thank you.
Take the small purse, please. Thank you.
Mr. Hepburn, are you able to hear me okay?
Yes.
Okay. Mr. Hepburn, have you had a chance to speak to an attorney about today's hearing?
Yeah, I spoke with the appeals attorneys about it.
Okay, were they planning on appearing? I don't see them, they haven't signed on to the hearing yet, and we're a little bit past the time. Do you know, were they planning on appearing today?
I mean, I would assume they were. They sounded like they were gonna.
Okay. All right, Mr. Rolla, you take any position on how we should proceed without Mr. Hepburn's counsel present?
Well, Judge, I don't, and thank you, Judge, for every record on that people. I don't know if there's been an appearance filed on this case by the appellate attorney, or whether it was a limited appearance specifically for the purposes of appeal as opposed to resentencing. The court may have that information in your court documents. I don't know. If it includes both, then quite frankly, I think the court will have to have sentencing continued to have that other counsel here. If they're not here, then you may want to consider a show cause to explain why they're not here. If they were on a limited appearance only for appeal purposes and not for resentencing, then we're dealing with a different situation, and the court can go ahead. It should have to instruct the defendant as to his rights to have counsel present in sentencing, which our appellate courts have determined is a significant part of the criminal justice system process.
All right, it looks like appellate counsel is still the counsel of record. They were served with the notice of date and time of today's hearing. So Mr. Hepburn, I mean, you're back before the court. Obviously, this was returned to this court from the Court of Appeals based on, you know, some confusion about your parole status and which Alpena case was controlling on your parole status at the time of sentencing here. You do have the right to have an attorney present at this hearing, and in fact, the court did order that your appellate counsel appear today. They haven't done that, so I mean, in my view, we would need to reschedule this, but
I mean, we can reschedule it, or I'm pretty familiar with it. You know, it's my case, so like this has just seemed to be way more confusing than it needed to be. I was on parole, so there's no jail credit. You know what I mean? Like, it's pretty simple, I thought. And my appeals attorney seemed to be slowing it down. Like, I'm grateful they got me into the courtroom, but I understand what's going on. If we can move forward, I don't know, or if we want to wait.
Okay, I mean, frankly, I don't disagree with you. I don't think it's complicated either. And so, but it's your right to have a lawyer present. I'd be willing to reschedule this when you can have one. If you want to waive that, I'm happy to go forward today though. So it sounds like you want to proceed today.
Yeah, we can proceed. We can proceed.
All right.
Your Honor, as long as the defendant makes it clear what's on the record, I think we can, but we're gonna need that so that we don't come back on further appellate proceedings.
So,
all right. First, I want to just, number one, I want to find out exactly which case, because if it was the earlier case, I don't believe consecutive sentencing would apply. And so any ruling of the court today would be in favor of Mr. Hepburn. I don't know if you're prepared to address that.
I don't even have the file, Your Honor.
All right, so I guess, you know, Mr. Hepburn, what we need to determine, and I need to get this information from the probation and parole department, and that is whether it was the Alpena case from 2021 that you were on parole for at the time this case arose, or whether it was the case from 2015 from Alpena.
it was the case from 2015. I wasn't. So the warrant for this retail fraud was issued before I even acquired the case from 2021, if that makes it any clearer.
Can you say that again? You broke up a little bit.
Okay, so I said I was on parole for the case from 2015. I was not on I was not on parole for the case in 2021. The retail fraud that I was actually sentenced on out of your court, that charge was issued and I had a warrant for it before I even caught the other case we're talking about. I wasn't on parole for it yet.
Okay. Here's what we're going to do for today's purposes. Ms. Davis, I'm going to ask that you provide something in writing to the court that we copy Mr. Hepburn on that as well, so that he can see that information. I tend to think that you're right, Mr. Hepburn, but I'm going to have the probation department give me something in writing. It'll be provided to you as well, showing what their records are with regard to that situation. If you're correct, then the court's simply going to issue an amended sentence saying that this should not be consecutive.
Thank you, Your Honor. That's the whole goal.
Which I think, yeah, I mean, that's what your position was on appeal, right?
Correct. That's exactly the issue.
Okay. All right. So that's how we'll proceed from here. If we need to have another hearing, then we'll notice that up and writ you for your appearance by video. But if the ruling is that it should not be consecutive, that's in your favor, and the court would not schedule another hearing at that point. Okay.
Sounds good.
Okay. All right. And Ms. Davis, can you do that like within the next 30 days?
I can, Your Honor.
Okay.
I can do it immediately.
All right. Thank you. Mr. Hepburn, did you have any other questions?
Not that I can think of.
All right. Well, anything further from your side there?
I don't believe so, Judge. I would indicate, however, the sentencing, the previous case, the 21 case was January of 2022, and the offense date in the matter he's before the court on was February 5th, 2021. So I don't know how he could have been on, quite frankly, parole or probation for the latter case when this offense occurred.
Okay.
I could explain that.
Sounds good.
You don't have to.
Okay.
Yeah. Okay, thank you. That's all for today, Mr. Hepburn. We're going to
Thank you.
Mr. Trush, were you ready on Mr. McKinnon's case?
I do not see Mr. McKinnon here yet. But it does appear there are some other folks who might be ready.
There's somebody in the hall.
Mr. Clayton, were you ready on Mr. Papp's case?
I am.
Okay, you want to come forward on that one? Is that a little early?
Appreciate that.
People versus Carl Papp. This is case number 236564. The record should reflect Mr. Papp's present here in court today. If I could have counsel put your appearances on.
Carl Papp.
This is set as a final status conference order, or status conference hearing today, and plea cutoff. We currently have trial set to begin on April 25th. So Mr. Clayton, with regard to the plea cutoff, does your client still wish to proceed to trial?
He does.
Okay. All right.
Judge, for the courts, for the record, we have the Laporte matter that was given priority that overlaps at the same time the TAP case is going. So I wanted to bring that to the court's attention.
Right. So Mr. Clayton, your case would be second in order. I'm not going to take it off the docket yet, but just so that you understand, Mr. Papp understands, the likelihood is that this other case will go. The other case has been previously adjourned and it's an older case, so it would take.
I'll be ready to go if something like our lives do. Sometimes things happen.
Okay.
And I should be noting my current appearance. This should not be an issue for trial.
Okay.
I should not be wearing this anymore on the 25th. Hopefully.
Yeah, no kidding. I'm sure that doesn't look like that's comfortable.
I'm waiting. They're hoping that the bone graft to my collarbone takes. They'll know I have on the 16th. They're doing some testing. They had to graft in some bone, put a plate, make screws in my collarbone, all from the car accident. So hopefully I'm at the very, very end of that endeavor.
Yeah, I do too. So
it's been a long go since October.
Sure. Okay, then just the court will notify you for some reason if this trial is going to proceed.
Sure.
Otherwise, the court will send out notice of the date and time for a new trial date on that.
Sure. Thank you very much.
Mr. Legal, were you ready with your case? People versus Black, case number 246682. Reflect Mr. Black present here in the courtroom today. If I could have counsel put your appearances on.
Ready to draw my phone back for people.
Kyle Legal on behalf of Mr. Black.
Mr. Legal, can you tell me where things are at with this file today?
Here, this is our first status conference in this matter. We have had some plea discussions, reached an agreement. We asked the court to set the matter for a trial with a final plea cutoff.
Okay, thank you. Mr. Rolla, do the people need any particular period of time to be ready to go to trial in this case?
No, Your Honor.
And how many days of trial, Mr. Rolla, do you believe will be?
Please, Judge. Judge, I'm looking at a circumstance where we only have 4 witnesses, which is what I thought. So you're talking a 1-day trial.
Mr. Legal?
I think a day is sufficient, Judge.
Okay. So we'll set it for a 1-day jury trial. Mr. Legal, do you need any particular period of time to be ready?
I would just ask for about 60 to 90 days, Judge.
We'll set it for a 1-day jury trial, about 90 days out. The court will, pursuant to its normal practice, set this for a final status conference prior to the trial date. And that will act as a plea cutoff. So Mr. Black, to the extent that you wanted to consider any existing or new plea offers, that final status conference would be the last day to enter into a plea, okay?
Okay.
Mr. Legal, are you anticipating any motions in limine?
I'm not going
Mr. Rolla?
No, Your Honor.
To the extent that either side does have any motions, they would need to be filed and heard no later than the date of the final status conference. Mr. Rolla, any other dates I can address with the people today?
No, Your Honor. Thank you.
Mr. Legal?
No, thank you.
Mr. Black, did you have any questions?
No, Your Honor.
Okay, thank you. That's all for today. Thank you. let's take about a 10-minute recess and we'll come back on the record at 10:45.
Your Honor, for the record, Michael, on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Mr. McKinnon.
How do we want to proceed on this file today?
Your Honor, I do think we have a resolution for the court. Mr. McKinnon would be pleading to counts 2 and 3, both of those being the financial transaction device 4-year offenses as a habitual second, so maximum, raising the maximums to 6. Count 1 and the habitual 4th would be dismissed.
Mr. Rolla?
That's an accurate statement, Judge, and of course, there's restitution for the matters.
And Your Honor, I do have a signed advice rights from the court.
All right, Mr. McKinnon, have you had a chance to speak with Mr. Church about this plea agreement?
Yes, I have, Your Honor.
Okay, and what we've said here on the record today is that what you've discussed with him?
Yes, sir.
Is that how you want to proceed today?
I do.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. McKinnon, are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty that you could face for counts 2 and 3, which are both counts of financial transaction device, stealing or retaining without consent, is up to 4 years and or a $5,000 fine and restitution. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the Court of Appeals, which is the next higher court up, to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I understand. No,
Has anyone threatened you with anything to get you to plead guilty?
no, yeah.
Has anyone promised you anything other than what we've said here today in court?
No, sir.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are guilty?
Yes.
So this happened in January of this year, is that correct?
Yes.
Okay, and at that time, did you use, was it a credit card or debit card, something like that?
Debit card.
Okay, and that belonged to a person named Andrew Kyer?
Yeah.
Okay, and what did you do with that card?
Put fuel in my truck.
Okay, did you do that on at least one occasion?
Yes, sir.
Okay, did you use it on a different occasion as well?
Yes, the same day.
Okay. And did both of those things occur here in Otsego County?
They did.
Did you have any permission from the owner of that card to use it for the reasons that you used it?
No, sir.
Mr. Rolla, do the people have any further questions?
He was satisfied for a sufficient evidence basis to accept the defendant's guilty pleas as to counts 2 and 3, but you will have to go into his prior history for this.
Oh, I thought I must have had it wrong. There is a half second.
Correct.
Okay.
And I'm sorry, I said the HAB 4 was dismissed. You might have got that mixed up.
Okay. That's right. All right. Mr. McKinnon, had you previously been convicted in 2018 of an attempted felonious assault in Crawford County?
Yes.
Oh. With that, Mr. Rolla?
People are not satisfied, Your Honor.
Thank you. Mr. Truce, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Church?
Yes, Your Honor.
Mr. McKinnon, the court finds that your plea is knowing, voluntary, accurate, or dissatisfied there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. You're going to meet with Ms. Davis before you leave court here today to set up a pre-sentence interview. And then just make sure that you stay in touch with Mr. Trush. We'll send you a notice of the date and time of the sentencing hearing. That's all for today. Thank you.
Your Honor, I did just want to make the court aware, Mr. Hilliker is here. I know he's early. I don't know if the Attorney General's here with it.
They have not signed in yet.
I think we next have Mr.
Worthington is, he's lodged downstairs. Is that correct?
Correct.
Can you call the jail and see if they can get Mr. Worthington in the
Yes, sir.
the polytown? Forget. No, thank you. All right, sir, is your name Joshua Worthington?
Yes, Your Honor.
Okay, we're on the record now in People versus Joshua Worthington. This is case number 246688. The record should reflect that Mr. Worthington is present today by video from Otsego County Jail. If I could have counsel put your appearances on.
Record Mike Roll, on behalf of people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Worthington.
Thank you. This is set for a status conference in this case today. Mr. Trush, can you tell me where things are at with this case?
Thank you, Your Honor. I do believe we have a resolution for today. The prosecutor has extended an offer to Mr. Worthington. If he pled to count one as a habitual second offender, they would dismiss the habitual fourth offense notice. For my discussions with Mr. Worthington, I do believe he intends to accept that.
All right, Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge, and as I also discussed with Mr. Trush, should there be any out-of-pocket expenses for medical care, otherwise covered by insurance, those would be included as restitution.
Thank you. Mr. Worthington, were you able to hear what Mr. Trush said about the plea agreement?
No, Your Honor. It was cutting in and out.
All right, so the plea offer in this case is that you would plead guilty to felonious assault or assault by strangulation as a habitual second offender, and in exchange for that plea, the prosecutor would dismiss the fourth habitual offender. Do you understand that?
Yes, Your Honor.
Have you had adequate opportunity to talk to your lawyer, Mr. Trush, about that agreement?
Yes, Your Honor.
Did you want to accept that agreement today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Worthington, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that by pleading guilty to assault by strangulation, that that is as a habitual second, and I'm sorry, assault with intent to do great bodily harm, less than murder, or by strangulation as a habitual second, the maximum possible penalty you could face would be up to 10 years or 15 years. Do you understand that?
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, Your Honor.
Did you have any questions?
Yeah, I know I can be sentenced up to 15 years. But okay, I'm just having I just would like to talk to my attorney would they be able to take the plea would they take the plea bargain out if I just want to request to talk to the attorney?
No, I want you to make sure that you fully understand everything that's happening before we do that. So I can certainly give you an opportunity to do that if you would like.
I would like to talk to the attorney if sorry.
No,
Your Honor.
no need to apologize. Like I said, it's very important that you understand everything that's happening. So Mr. Trush, you want to try and do that yet today?
So what I would propose to the court now, follow the court's direction. I see Mr. Brown has come in. I don't know if there's some other cases the court could handle while I went to another room and logged in with a different device to talk to him, or if the court wanted to address it in the afternoon. I know I'm back here at the end of the afternoon. Either way the court wanted to go, I suspect we can make some progress today at least.
Okay, I think let's do that. Why don't you sign other matters that I can address? So Mr. Worthington, I'm going to put you into a breakout room with your lawyer by video so that you can have a private conversation with him, okay?
Okay, I appreciate it.
Yeah, it's just going to take a couple minutes here, but you just stay right where you're at.
Okay.
If Your Honor, happen to have the meeting ID handy.
Know it all. Hang on.
All right, I've got it.
You got it? Okay.
I was gonna say, I got it now.
Okay. Should have this one.
Okay, so Mr. Truce, I'm gonna go ahead and put you into a breakout room with Mr. Worthington. Mr. Rolla, were you ready on Mr. Matthews' case?
Yes, Judge.
Okay. All right, Ms. Calgary, are you able to hear me okay?
Good morning, Your Honor. Yes, I can.
Okay, we're on the record in People versus Jonathan Matthew, case number 195787. And the record should reflect we have Ms. Galgara on behalf of Mr. Matthew, present by video. Mr. Rolla is present here in the courtroom. This was set as a status conference. After the court set this for a status conference, the court received an order from the Michigan Supreme Court remanding essentially the case back to the Court of Appeals for further consideration, which in my view means we don't have much to do today in light of that. Mr. Rolla, do you interpret that any differently?
I would just add a single additional caveat, Judge, that pursuant to the Michigan Supreme Court's order, that a appellate brief has to be filed with the Court of Appeals by April 5th, as indicated in the order.
Okay. Thank you. In terms of proceeding on the file here in this court today, Ms. Galgara, would you agree that we just simply need to wait for the Court of Appeals to rule on this?
I would agree, Your Honor.
Okay. All right. So the court will continue to monitor that. Once we have the case back from the Court of Appeals, the court will set it for further hearing and notify both counsel. Mr. Rolla, anything further for the record on this case today?
Not that we can do, Judge.
Ms. Galgara, anything further from your side?
I just want to apologize, Your Honor. There was a miscommunication between my office and Mr. Matthew with regards to if he thought that he was able to appear via Zoom, which is why he's not present in the court. I just wanted to let you know that it was a miscommunication, that I'm actively communicating with Mr. Matthew. He's on standby, ready to log in Zoom it if needed. I just wanted to make sure that the court, doesn't think that Mr. Matthew wasn't, shirking his responsibilities or anything. That miscommunication from my office is why he's not there.
All right. Thank you for noting that for the record. Again, in light of our inability to go forward with the case today,
Right.
I don't think it's a problem, but in the future, as long as he's present, ready to go, we'll be good.
Thank you, Your Honor.
Okay, thank you, Ms. Galgara. You're free to disconnect at this time.
Thank you.
Are we ready on Mr. Baird's case?
Yes, Your Honor.
Okay. The court will call People versus Michael Baird, case number 236601.
Very John, I call that people.
And if I could just have Mr. Baird and counsel there at the podium, please. We we are set to proceed with trial on April 23rd in this file. Today is set as a final status conference and plea cutoff. Mr. Norman, does your client still wish to proceed to trial in this case?
He does, Your Honor. It's Velo now. Norman was the prior counsel, so I don't know if you have an update. Yeah, no problem. Just wanted to, for the record.
And Judge, on that note, I'm in contact, my office made contact with the clerk's office yesterday. They hadn't had an appearance yet by apparently his new counsel.
Okay.
We weren't sure who was going to appear today. I was told his prior counsel was still the counsel of record. So
Well,
if that hasn't been done, I please ask that you do so.
No, same law firm. And
Yeah,
so-
I understand that.
Okay.
I realize that,
Yeah.
same firm, but different person.
And Mr. Morris is going to be handling the trial, so you can expect him for that.
Okay, so we're not changing
Oh, we're
counsel.
not changing anything.
Yeah.
All right, no problem. All right, Mr. Rolla, are there any issues that we're gonna need to address prior to trial in this case?
I don't believe so, Judge.
Mr. Deal?
None for defense, Your Honor.
Okay, all right, so Mr. Baird, and if you can notify Mr. Morris, just need everybody to be present, ready to go by 8:30 on the morning of trial.
Certainly, Your Honor.
And we'll begin with jury selection and then go right into openings and proceed with the case.
Perfect. I will let Mr. Morris know.
Okay.
One judge thing for the record, if I may, Your Honor. There was a 404B notice filed in this case by the prosecution. I haven't seen the response or objection filed by the defense. I just wanted that indicated for the record.
Okay. All right. Okay, anything else that we need to address?
Nothing further for defense. Thank you, Your Honor.
Mr. Baird, any questions at all?
No.
Okay, thank you. That's all for today then. We'll see you on the morning of April 23rd.
Thank you, Your Honor. Have a great day.
Oh, one thing you might want, Mr. Theo, also let Mr. Morris know, just because it's a procedure that's particular to this court, if he wants to review jury questionnaires, he just needs to contact the clerk's office to get approval for that.
Okay.
To the trial date. And then, do you know if he's gonna need to use any kind of technology?
I'll have him contact the court if he is.
Please do. Okay.
Thank you, Your Honor.
All right.
Have a great day.
Thank you. Thanks. Okay, Mr. Trush, we've got. Mr. Worthington, are you able to hear me?
Yes, Your Honor.
Okay, so Mr. Worthington's back. Did you have a chance to speak with Mr. Worthington?
I did. We cleared up some questions he had about the guidelines.
Okay. All right, Mr. Worthington, did you have an adequate chance to speak with Mr. Trush? Are you ready to proceed?
Yes, Your Honor.
Okay. So before we took that little break, I had just gone through all of your rights with you. And you indicated that you understood that you have all those rights. Is that correct?
Yes, Your Honor.
And do you understand that you're giving up all of your rights by pleading guilty, including the right to have a trial of any kind?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we've said here in court on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Okay. Mr. Trush, I'm going to ask that you address the question of your client here due to the lack of specific facts in the information.
Okay. Mr. Worthington, can you hear me okay?
Yes,
So on or about January 26th, I think that's 26th of 2024, were you here in Otsego County?
yes, sir.
And were you at the family fair on that date?
Yep, yes,
And while you were there, did you have in your possession a knife?
yes, sir.
And while you were there, did you stab someone with that knife?
Yes, sir.
And when you did that, you knew that that was going to cause harm to them.
Yes, sir.
And have you previously been convicted of at least one prior felony?
Yes, sir.
And was that a resisting and obstructing out of Sheboygan County in 2008?
Yes, sir.
Yeah, I think that would establish basis.
All right, Mr. Rolla, are the people satisfied with the factual basis?
The only question that we might have in regards to the intent was was the victim actually require medical attention, since this is an intent to be found the harmless and murder.
Mr. Trush, is there any stipulation as to that? I don't know whether Mr. Worthington would know that or
And again,
not.
I think the parties will stipulate the victim did actually drive himself to the ER and had to receive medical attention.
Yes, we would stipulate there's injuries, but I would tend to agree with the court. I don't know that Mr. Worthington could establish what happened after the fact.
Right, yeah, okay. All right, Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Trush?
I'm aware of none, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yeah, thank you.
Mr. Trush?
We are satisfied.
Mr. Worthington, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. The court is going to set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Prior to that, somebody from the probation department will be in touch with you to do a pre-sentence investigation. Mr. Rolla, is there anything further we need to address today?
So there's a lot of feedback there. I would indicate Mr. Worthington does have some mental health issues, so I would ask to be present with his doctor.
Okay, Ms. Davis, if we could just coordinate that with Mr. Trush. Thank you, Mr. Worthington. That's all for today, and the court is going to disconnect at this time.
Thank you, Your Honor.
Okay, versus Hilliker. That is case number 236541.
That's the AG, please, Judge.
Yes. Okay, Ms. Brenner, are you able to hear me okay?
Yes, Your Honor. Good morning.
Good morning. We're on the record in People versus Mark Hilliker. And the record should reflect Mr. Hilliker is present here in the courtroom today, along with his counsel. We have Ms. Brenner on behalf of the people present by video. This is the date and time set for sentencing in this manner. Mr. Hilliker, have you had an adequate opportunity to go through the report and speak to Mr. Trush about that?
Yes, sir.
Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
And are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Brenner, do the people have any additions, deletions, or corrections?
Yes, Your Honor. I would just update the balance on item number 10 on page 2. It says pay restitution in the amount of, and it says balance to be noted for the record. So I'll give you that number. It is, as of today, it's $719.58.
Mr. Church, any objection to that?
No, Your Honor.
Okay, the court will order that paragraph 10 be amended to reflect that amount.
That's the only one I had, Judge.
Okay, Ms. Brenner, do the people have any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
Your Honor, I was advised that she was going to be in the courtroom today. I don't know if she is there and if she wishes to speak.
Okay, Mr. Truce, if I could.
Ms. Harding, I think, is present.
Okay, if I could have you and your client move off to the side there, Mr. Brown, you've got some space. And Ms. Harding, I'm just going to have you come forward to the podium there, please. All right.
Hello.
Good morning. Can you tell me your name?
Samantha Louise Harding.
Okay, and can you tell me your relationship to this case?
Mark is my ex-husband, the father of my 14-year-old dog.
Oh, can you tell me what it is that you would like the court to know?
Mark hasn't been around a lot of the years. He has tried to reach out and have visitations with Caitlin as she wanted them. This is the first time he's been paying child support consistently. Really like to see that continue along with my daughter. I don't want him to sit in jail. I want him to keep paying. Took him a long time to get us here and it's finally happening and it's helpful.
All right, thank you. I appreciate your statements today. Ms. Brenner, anything that you wanted to state on behalf of the people for allocution?
Your Honor, the defendant does have an income withholding order in place at this time. But he has another child support order in another county. So his payments are all split between this case and his other child support case. So he's not quite meeting his monthly obligation. So while he is making consistent payments, he's continuing to go farther into the hole instead of paying down the arrearages. So he may need to look at an additional job opportunity or potentially trying to get his orders reduced so that he can be maintaining the current obligations. So I would be requesting no upfront jail, just time served, and a longer period of probation because I think he's going to need additional time to try to pay down this balance. So I would be asking for the full 3-year period of probation so that hopefully he can make headway on that arrearage during that time period.
Okay, thank you. Mr. Trush, anything on behalf of your client today?
Yes, Your Honor. So a few things that I do want to point out to the court. Obviously, the guidelines in this are fairly low. Mr. Hilliker doesn't have any prior history, so to speak of. And I point that out because he has credit for 69 days against a guidelines range of 0 to 3 months. So it makes perfect sense to not impose any additional upfront jail. He is making consistent payments. I would indicate he's currently working 2 jobs. I believe right now, he's indicated to me that if and when we get spring actually to break up here, he intends to do like landscaping work as well. I guess what I would indicate to Your Honor is I think this is a case where he had a problem. He kind of got in over his head and he did what isn't a good idea, but what a lot of people do. He kind of stuck his head in the sand and ignored it. And the court, I'm sure, is well aware that doesn't make problems go away. Rarely, if ever, is a successful strategy for that. But it leads him to a point where he got to an insurmountable place. He's got a huge amount of arrearages he has to pay off. From the moment that I've had contact with him, he's expressed that he wants to get this done. He immediately, upon being released, got work, has been making consistent payments. The effort's there. I guess that's what I want to emphasize for the court. I think he does have, some limited means in terms of what he can make and what he can pay. And it's a big hill for him to go over. But again, there's consistent effort from what I'm seeing here, such that I think I would suggest to the court that it is appropriate to give him, time to do that. I don't know that we need, a 3-year term of probation, because even in a 3-year term, I don't know that we're going to see it completely erased. because he does still have ongoing obligation in addition to the arrearages, at least on, I think, 2 of his children. So I'd leave it to the court's discretion how long that term needs to be. I would suggest to the court, in the interest of, again, trying to get over that mountain, anything the court could do to reduce the obligations he's gonna have to the court in terms of fines, costs, possibly waiving the court-appointed attorney fees. Again, I think all of those things put him in a position to better be successful. And frankly, from my perspective, I would rather see that money go to the arrearages and go to the children. Thank you.
All right, thank you. Mr. Hilliker, anything you wanted to say today?
Yes, I would just like to take this opportunity to apologize to the board and to all those involved.
Thank you. I did review the report, so I'm familiar with the circumstances here. Was helpful to hear from Ms. Harding as well, to get her perspective. And I think everybody's in agreement that the goal here is to get you to continue making payments and pay down the balance that you owe. And I think a period of probation to monitor that is appropriate. I think what Ms. Brenner is suggesting, a lengthier period of probation, is appropriate too. You're going to have the ability to be discharged early from probation. So it doesn't necessarily have to go the whole 3 years. And so I think, the opportunity is there to be discharged from your probation early. If things go the right way and you're able to make substantial payments, and if not, then we'll just keep monitoring it for that period of time. So I agree with the recommendation of the people, which is for a longer period of probation. I also agree with Mr. Trush that to the extent the court can waive certain fees, I'd rather see Ms. Harding get those funds than have them be collected by the court. I think in this case, that's a better use of your money and your time, is to go to the benefit of your child. So the court's going to order him as part of the probation, with the idea that the court may ultimately waive the attorney fees and court costs. Some of the other costs I can't waive, I have to impose them by statute. But the ones that can be waived, I think the court would be willing to waive those if you do well on probation and if you're following through. So the court is going to place you on probation for 3 years. The court's going to adopt as the conditions of that probation all the terms and conditions in the report. The most important of which, of course, are that you continue to pay your monthly obligation and that you make efforts to reduce the arrearages as stated in paragraph 10. The court is going to order that you serve 69 days in the Otsego County Jail with credit for 69 days served. A crime victim's assessment of $130, supervision fee of $30 per month, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Trush is going to provide you with some papers that explain what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Ms. Brenner, while we're doing that, is there anything further on behalf of the people today?
No, Your Honor, thank you.
Mr. Trush, has Mr. Hilliker received his appellate rights?
He has, Your Honor.
Mr. Hilliker, thank you, and good luck to you going forward.
Thank you. I'm sorry.
Thank you, Your Honor.
And Ms. Brenner, you're free to disconnect at this time.
Does he need to meet with Ms. Davis?
On Friday, I already talked to him.
Okay.
Show the trial on the 23rd and 24th. We show report for 24, 25, 26.
I'll talk to Jennifer. We'll get that.
Okay.
Yeah.
All right, thank you. Unfortunately, I didn't notice that until after the other attorney left. Otherwise, I would have brought it up on the record.
All right, Mr. Brown, we have Mr. Chris appearing by video. Are you ready? And that's our last matter for the morning. Matters, I should say. Okay, Mr. Crisp, I just need you to unmute, please. All right, are you able to hear me okay?
Yes, sir.
Okay. All right, we're on the record today in file number 236585, 236512. Those are current felony files, and then probation violation files 216237 and 6235. The record should reflect Mr. Chris is appearing today by video from Bear River, I believe, and
Harbor Hall.
Or Harbor Hall. Okay, thank you. And if I could have counsel for your appearance.
Thank you. For the record, Mike Brown, on behalf of people.
Larry Brown on behalf of Mr. Chris.
Okay, Mr. Brown, I believe both the newer files were consolidated for trial, is that correct?
No, they were not. I think there was going to be a consolidation of the retail fraud case, which would have been 6585 with the other co-defendants.
Okay.
Correct, Judge. That's the motion that was filed on the court got on the first, although I had it ready on the Thursday before Easter.
Okay. So is that going to affect the trial? We currently have a trial date of April 22nd, that file.
I guess Mr. Brown's gonna have to answer that.
Okay, Mr. Brown.
I'm not really sure, Your Honor. This is very recent. I haven't spoken to Mr. Chris about the consolidation.
Okay.
It might not make a difference after today. I'm not sure.
Okay. How do you want to proceed today then?
I have talked to Mr. Chris about these files. There has been a plea offer in each of the files, the newer files, to plead as charged as a habitual second. The remaining counts, as well as the habitual fourth offense, would be dismissed. However,
okay, which files? And
in file 6512.
6512 plead to
count one
as a second,
or dismissal of the remainder as well as the remaining habituals.
okay. And then how does that, and then what about 236585?
The same thing, plead, I think there's only one count, plead to count one as a have to dismiss the remaining habitual.
Okay. All right, and you said you've spoken to Mr. Crisp about those.
I have, and I'm not quite certain he understood all of this, but I want to make it clear on the record. He also has 2 probation violations pending. I spoke with Ms. Davis. She would dismiss one of them. However, there would be another violation of bringing the contraband into the prison, which is obviously, if you tender to plead, that would automatically be a probation violation, which I believe, because it was in the jail, would run consecutive to any other sentence. So I want to make that very clear on the record. Do you understand all of that, Mr. Chris?
Somewhat, yes.
What part don't you understand, or what part do you have questions about?
The concurrent. The concurrent and the other part, I don't really understand. Were you
So
running
if
concurrent or consecutive?
So if you accept the plea agreement, in your newer cases, it means that you're gonna have violated your probation in your other case. And because one of the charges involves furnishing contraband to other inmates, whatever you get for your probation violation, whatever sentence that is, has to be consecutive to whatever sentence you get in the other two cases. So in other words, it would have to run back to back.
Okay.
So
I
your
understand.
decision. What's that?
I said, I understand what you're saying now.
Okay. So then the question is whether or not you want to go forward with that today or not.
Mr. Brown,
Yes,
yes or no?
well, I can't tell you how to plead. We discussed this yesterday. It was my understanding you were going to, but that is, I can't tell you to.
All right. I'll
I
accept
mean-
the charges, Your Honor.
Okay. All right. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Chris, I know you're on probation and we've already gone over that. Are you on any kind of parole or any other status?
No, sir.
Okay.
And I'm actually supposed to, if I was to pay my fines in Gaylord, I would be coming off in November for the paper that I was already on.
Okay, something that I'm gonna need you to do for the rest of the hearing is I'm gonna need you to sit down and stay in one place, because when you move around, your signal changes and you break up.
Yes, sir.
So
Sorry,
please just
sir.
remain in
Sorry, sir.
one spot. That's all right.
Yes, sir.
Okay, there we go. All right, so in file number 236512, under the plea agreement, you're gonna plead guilty to furnishing contraband to an inmate as a second habitual offender. That means that the maximum possible penalty you could face would be up to 7.5 years on that charge. Do you understand that?
Yes, sir.
And then in file 236585, you're gonna plead guilty to 1 count of retail fraud first degree, also as a second habitual offender. The maximum penalty that you could face for that charge would be up to 7.5 years as well. Do you understand that?
Yes, Your Honor.
And then, as I said, by pleading guilty to the furnishing contraband charge, you're essentially going to be pleading guilty to violating your probation, and that sentence will be concurrent consecutive or back to back. Any sentence that you receive in either the 236585 or 236512 files. Do you understand that?
Yes, Your Honor.
With all of those things in mind, how do you plead to the 2 charges that I mentioned?
No contest?
All right, my understanding is that you're going to be entering a guilty plea here today.
Yes.
Okay, so are you going to plead guilty to those 2 charges then?
Yes, Your Honor.
All right, and you understand that you're also going to then be pleading guilty to a probation violation for furnishing contraband to prisoners.
Yes, sir.
Okay. Has anybody threatened you with anything to get you to enter this plea today?
No, Your Honor. I just don't want to waste no more of your time in court.
All right. Has anybody promised you anything other than what we've talked about on the record here today?
No, sir.
right? Is it your own free choice to plead guilty to these charges?
Yes, Your Honor.
And are you pleading guilty because you are guilty of each of these charges?
Yes, Your Honor.
Okay, so I'm gonna go through a few things with regard to your rights. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand that you have all of those rights.
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, Your Honor.
You're also going to be giving up any right that you would have to a hearing as to whether or not you violated your probation. Do you understand that as well?
Yes, Your Honor.
Okay, so I'm going to ask you first about file number 236512. That's the charge of furnishing contraband. That occur on or about January 18th of 2023.
Your Honor,
Do you have any reason to doubt that that's the wrong date or the right date?
I mean, I just deny the whole situation because I never furnished Suboxone to anyone inside the jail.
Okay, did you arrange with another person to help that person do that?
No.
You didn't have anything to
Because
do.
I've thought the whole time that I've been on this charge that it was for bringing contraband into a facility, not giving it to other prisoners or however you're putting it.
All right, well, tell me what you did then.
There was a phone call made and someone brought a book to the jail and it had contraband in it. I didn't furnish it to no inmates. I didn't give it to any inmates. I never received it.
Okay, what did you do?
Talked on the phone about a book.
You talked on the phone about what?
Bringing a book for me to read, and it had a Suboxone strip in the back of it. It never made it to me. It never went through no further than the front locked doors of that jail.
All right, so you made a phone call and you asked somebody to bring a book for you that had a Suboxone strip in it and bring it into the jail and get to you. Is that right?
Pretty much.
Okay, did that happen here at the Otsego jail?
Yes, sir, it did.
And did that happen in January of 2023?
I know it was somewhere around that time, Your Honor. At that point in time, I wasn't currently on my meds correctly, and I was hallucinating for over 2 months before I was ever took to the hospital to be checked out and was unconscious. I have my caseworker from CMH as a witness on that. I don't really remember nothing much about those 2 months that I was in the county jail. Because I was only there 2 months to flatten out a 10-month sentence on work camp.
And was that in January?
I've been told. Huh?
Was that in January of 2023?
Yes.
Okay. Mr. Rolla, are the people satisfied with the factual basis?
As long as the court takes judicial notice that the county jails here in Otsego County, the court has sufficient factual basis to accept the defendant's guilty plea to count one as entered.
I would agree. Okay. All right, Mr. Chris, then I'm going to ask you about the retail fraud charge that happened in May of 2023. Is that right?
Yes, sir.
Okay, and was that at the Walmart here in Gaylord?
Yes, Your Honor.
Okay, and did you take some property from the Walmart in Gaylord?
I put 2 items in the bag or in the car, in the buggy, and that was it. And I walked out with my wife and myself. Did not carry the buggy, did not touch the buggy. And as far as I was concerned, they were going back into the store. We were going to sit down at the bench to wait on my niece to come back in for breastfeeding her kid and pay for the remaining items that had been put in the buggy already. And that was it. I didn't personally steal anything. And I'm sorry, but it's the only way I can kind of get the whole situation out, because it's been stated so many different times that it was just something different, and I personally did not steal anything. There was nothing on my person nor in my vicinity of my pockets. I did not steal anything.
Okay, well, you know, you said you put a
But the
couple
only
items
reason
in.
The only
Said
reason
you
I
put a couple items in the buggy, is that right?
Yes, sir, I did. I stuck some tissue paper and a bag for a birthday present in the car.
Okay, what else was in the cart at the time?
Household items that I'd seen. I'm not sure exactly. They were all in blue bags already. So to my understanding, the stuff had been paid. They were in Walmart bags.
Okay, so you walked out with that cart out of the store?
I did not walk out of the store with the cart. My wife did. She's already been charged for it and is sitting currently in the penitentiary.
Did you know that she was leaving the store with those items in the cart, having not paid for those?
No, sir, I did not. We were going back to the front of Walmart to where the chairs are at, next to the pop machine, and my niece was coming back out. My niece had to go out and breastfeed one of the kids while we picked out her birthday present, and they were going to pay for it all at once. And from what I was told, it was already paid for because it was in the blue bags, that they just had to pay for the birthday gift that my wife put in there, a tissue box or a tissue paper and a bag.
So you're saying you had no idea that any of this stuff was being stolen and you didn't participate in it at all?
No, sir, I did not.
You were completely surprised by the whole thing?
Yes, sir. I was the last one in the store. I thought everything was paid for. They were already in blue bags.
Okay, I don't think we can take a plea to this charge. So Mr. Crisp, if what you're telling me is your testimony, then we can't go forward with the plea agreement, because I can't find you guilty of stealing things from Walmart if you thought it was paid for and you had no idea and you didn't participate in taking those items. So.
Okay. Well, I wanted my chance to be able to talk to you. You've been an understanding judge since I've been coming in front of you. And I don't feel just because certain police officers in Gaylord have a hard on for me that I should get in trouble and just plead guilty to something that I honestly had no clue of.
Okay, yeah, I mean, I agree. So, Mr. Rolla, I'm assuming that this is all part of one agreement, or?
Well, Judge, that was the general idea, but again, the people have no objection to the court accepting the defendant's guilty plea on the other 5.
Okay. All right, so Mr. Crisp, I'm gonna have you talk to Mr. Brown some more about the retail fraud file. As of right now, you still have the right to go to trial on that case, okay? And we currently actually have a trial date set for that. So we're not gonna address that one. The court is going to, well, first of all, as to the furnishing contraband charge, Mr. Rolla, do the people aware of any other threats, promises, or inducements with regard to that charge?
No, Your Honor. No, Your Honor.
Are the people satisfied that the court has complied with statute and court rule in the taking of the plea as to that file?
Yes, Your Honor.
Mr. Brown?
Yes.
Okay. All right, so Mr. Crisp, with regard to the charge in the jail, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of that charge. the court will accept your guilty plea as to that count. The court also finds that based on your plea, there's a sufficient factual basis to find that you did violate your probation by engaging in that conduct, and the court will find you guilty of the probation violation as well. We're gonna set those matters for, we'll set those matters for a sentencing hearing, and you'll be notified of the date and time of the hearing as to those issues. Somebody will be in touch with you for a pre-sentence report on that.
Your Honor, can I just state on the record, because there's bench warrants and there's a show cause. And I just want to make sure that all of it's addressed. We're dismissing the show cause on where he failed to report and where he allegedly went to Tennessee. So that show cause would be dismissed.
Yes.
And then he would plead guilty to just count 1 of the bench warrant, and count 2, the retail fraud offense, I'm willing to dismiss.
Okay.
On both dockets.
Okay.
Just so that that's on the record.
Perfect.
For 1 count.
So that clears everything up, and all we're left with outstanding is the 658 file.
Correct.
Okay, great. Okay, and then Mr. Crisp, again, you're gonna have an opportunity to speak with Mr. Brown about that retail fraud case and how you want to proceed with that, okay?
Yes, Your Honor.
Okay, all right, thank you. That concludes the hearing today, and Mr. Crisp, you're free to disconnect at this time.
Thank you, sir.
All right, that concludes our morning docket. The court will be in recess until 1:30. Mr. Rolla and Mr. Brown, I do want to let you know I have an appointment over the lunch hour that I might be a few minutes late for the 1:30. So I just want to let you guys know ahead of time. It might be more like 1:40 before we get started. Maybe not.
Appreciate court continuation.
Oh, great.
Thank you.
You're
We'll be in
just gonna let
recess.
us sit.
What's that?
You're just gonna let us sit here.